for joining us today with the Davis-Bacon Act Compliance Principles Review with Mike Staebell with the Dickinson Law Firm. My name is Jared Herridge. I'm your Membership Director with ABC of Iowa. Again, thanks so much for your time this afternoon. Mike is going to be taking about an hour of your time to go over some of the surface levels of the Davis-Bacon Act. And so what I'll do is I'll hand this directly over to Mike.
Okay, thank you, Jared. Welcome, everyone. We apologize for a little bit of a glitch here, but it's high tech, so we're working on it. Yes, today, of course, we are going to be talking about this great law, the Davis-Bacon Act. And I just want to share a little bit with you folks. First off, a couple little quick housekeeping things. On that collapsible menu that's on the right side of your screen that you can slide over, one of the things you see are handouts. And there are 3 handouts on there. So everything I'm going to cover today is there. And if you're interested in having a hard copy, you can hit download and print those out. If you care to keep your notes on them, etc., that's just fine. But it's exactly what we're going to have on the screen. But that way you've got the handouts. You can keep them later. You can use them to take notes, whatever. So feel free to avail yourself of that if you choose to. But a bit about my background, for those of you who aren't familiar with who I am. I spent 33 years working for the Department of Labor, the Wage and Hour Division of the U.S. Department of Labor, and that's the agency that enforces the Davis-Bacon Act, among others. And I spent 17 years as an investigator. I spent 16 years as a manager there at various offices, and I'm just going to give you an estimate that I probably participated as an investigator or a supervisor in over 500 Davis-Bacon investigations, and that's probably conservative. Simple ones, hard ones, every aspect known to man. So I feel like I have a pretty good background in this law, and I've certainly done many presentations on it. So I'm sure open to the questions that you may have. And what we're going to do for questions is there is a question field, again, in that collapsible window to the right. And you type in your question. We're going to save those for the end, though. We're going to quit about 10 minutes early and then deal with the questions at that point, okay? So if you want to wait till the end to type in your question, you may, or you can type it as we go along, but we'll deal with it at the end. So we're going to talk about the Davis-Bacon Act today, and we're going to go to our first screen. These are the topics we're going to cover now over the next 45 minutes or so before we get to questions. I was saying to Jared as we were getting ready for this, you know, the difficulty today is not in what to talk about, but how to condense it down to an hour. So I'm picking the areas that are critical areas that everyone needs to know about. But also these are areas that in my years of enforcing this law, I saw many problems. And I'm not going to blame the contractors for all the problems. It's the nature of the law. It's extremely complex. So be aware today, we're covering, you know, in kind of a shallow manner, the big issues on Davis-Bacon. If things work out, you know, we may wind up doing another one of these and getting into more detail on certain aspects of it if there's an interest or a need out there. And of course, as we look at the political landscape and the talk about infrastructure and the billions, or I guess trillion-dollar infrastructure bill, at least as our laws work now, most of that would be subject to Davis-Bacon. So we could very possibly see a huge explosion, you know, in Davis-Bacon projects, as we did in 2009 with ARA, because that's exactly what happened then. So I'm not going to read all these off to you because we're going to cover them each and every one separately. And bear with me a little bit. There will be a little bit of bouncing back and forth because these things kind of cross-reference and they kind of reinforce each other. So the first thing we want to talk about is payroll and record keeping and the things to remember. Those of you I know that have done Davis-Bacon jobs know some of this, but I want to cover it for those that may be new to it or haven't done it for a while. Regardless of the pay period that your firm has, the Davis-Bacon Act requires weekly pay. And I wish I had $1 for every contractor that called me when I was with the Department of Labor. Hey, can we figure out a way to pay 2 weeks? No. Can't we pay? No. You got to pay every week. It's right in the regulation. There's no way around it. So contractors who don't normally pay weekly are going to have to pay weekly, at least those employees who work on these projects. Okay? So that is a critical very basic, but still a very critical fact you need to remember. If you're bidding projects and you're on a biweekly pay period or something, you just need to realize we're going to have to make some allowances so we can cut checks every week, at least for the federal wages, for the Davis-Bacon wages, okay? The second thing on the screen that people goof up so many times, and there's reasons for that, but it's the certified payroll form. This is the form where the contractor has to report the hours and the pay and the type of work done by their employees on this project. Now, we're going to come back to that here in just a second, but the form that the Department of Labor puts out is called the WH-134. Well, I've got another form I want to show you that's a takeoff on that, but we're going to come back to that next, but after this slide. But I wanted to tell you that the third thing about payroll and record keeping that is absolutely critical is one of the big hang-ups in complying with Davis-Bacon is segregating the work that your folks are doing, okay? You know, the law requires that if I'm working, you know, in one trade for part of the day on a project, and then I switch to another trade or another task, there's probably a different rate of pay for that. And so many times in my world with the Department of Labor, we go into these employers, these contractors, and they weren't really tracking that. Well, if you don't track it, you're setting yourself up for trouble, because you know what the Department of Labor is going to do if they come and visit the project? Or DOT has inspectors, HUD has inspectors. It's not just DOL. They're going to say, they're going to go interview your employees. And they're going to ask Jared, you know, what he did that day. Well, you know, I brought that backhoe from about 9 to about 10:30, and then, you know, they were short on the cement crew, so I had to do some cement work, you know, some finishing work and blah, blah, blah. But the employer had no record of that. Well, what happens with the Department of Labor, they're going to take the employee's word for it. So you're at their mercy. If they say, well, I spent all my whole day on that backhoe, you've got to be sure and track somehow in your timekeeping system that Mike spent so many hours doing this and so many hours doing that, because they're going to hold your feet to the fire. And this is one area where merit shop is at a disadvantage. Because you know, if anyone's ever been on a union job site or worked a union job, if you go to an electrician and say, hey, I need you to go nail a couple of those boards over there, that electrician's on a union job and say, that ain't my job, I'm not doing it, go find somebody. But your good, solid employees in the merit shops, the non-union shops that do a lot of stuff, yeah, they do whatever they need to do to get the job done. So the burden is a little harsher on the non-union shops, because, you know, the employees are going to do what they're told. So be aware of that when you're making these records, okay? So what I'm going to do is show you this for a second. We're going to leave the PowerPoint for just a second, and I want to show you this form. Now, this is the form, and this goes right to segregation of time. Yeah, that's a good view. I like it. Let me tell you just a little bit about this form. Even though the Department of Labor has their form for recording your federal payrolls, your Davis-Bacon payroll, that's not required, okay? By law, you have to record all this information. You don't necessarily have to use this form. Well, the good folks over at the DOT in South Dakota came up with their version of the form, which has been accepted by the Department of Labor. Now, whether you use this form or not, bear with me for a second. One of the hang-ups on the form is the area here that's shaded. On the federal form, this is not so clear. You not only have to record, such as over here, you know, the employee's name, you know, what work they're doing, labor, group one, whatever, the hours, straight time, overtime, the pay, all this stuff, then you've got to report their whole weekly payroll as well, even if they only worked one day on this federal job and 5 days, 4 days, whatever, on non-federal work. You've got to show that. Well, the federal form is really lacking in a good way to report that. This form is very neat. It's very handy. And as I say, it's very, very close to the federal form. So you may want to consider this. The other thing is this is all Excel, so it's got its formulas in there, and you can type in, you know, the hours and the wage, and it'll compute the pay for you and everything else, so that's nice. But even if you choose not to use this form, because particularly if you're a subcontractor, you would need to talk to your general contractor about the use of this form, and they would have to accept it. This form is really what allows the agencies to determine the hours on the job, who was on the job that day, what jobs they did, and to get the compliance. And if you don't fill out these forms, somebody's probably going to be on your case, whether it's the prime or the general contractor or the funding agency or whatever. Now, if you happen to be a general contractor and you like this form, you're going to need to check with whomever you send these forms to. It might be the agency in the case of HUD or DOT, or it might be a firm that is hired by the owner of the project, you know, a consulting firm or an engineering firm. So you want to check with them first. But even if you don't, here's why I love this. First off, they have a PDF here. I'll just go to it. It looks the same. Oops, I'm sorry. I'm on the PDF. I need to go to the here we go. So this, I'm sorry, this is the Excel version right here where you can fill in. The first one is just a PDF you print out and you can fill it out by hand, however you want to do it. But the real bonus here, folks, are these instructions. And I tell you, when I first found this, thanks to one of our attorneys, Russ Sampson, a great guy. Some of you probably know him. Super good with Davis-Bacon as well. Russ turned me on to this, and I'm not going to go through this today. We could spend an hour, hour and a half on this form if we chose to today. But there is so much good information and guidance, and it tells you how to fill out every single thing. Even if you don't use this form, I strongly suggest you print out these instructions. They are so helpful. They're concise, they're to the point, they tell you what you need to know, okay? Now you have this, and hopefully you can print that out. Otherwise, if you're looking for it, you just go to South Dakota DOT. Just Google South Dakota DOT forms, and you'll find certified payroll form. And they also have the form on the back that it has to be signed by an official of the contracting firm. And before we leave our discussion and move on to something else, before we leave this discussion of the certified payrolls, let me say one other thing. On the back, it's actually called a certification because the employer is certifying that everything on the front side of that form is true. Now, even if you're using this form, it's information for a federal project. So if the information is falsified on this form and it's signed, that's a criminal act. Now, in my career, I will tell you, when people didn't do this form right, 99 times out of 100 or more, it was just an error. So you don't get sued, or you don't, get fined or go to jail for making an error. But I'm going to tell you there was 10 or 15 investigations that I was part of where it was determined that employer deliberately falsified the front side of that. Now, I know none of you would do that, but I just want to point out the fact that it's a $10,000 fine and 5 years in jail, max. And I was involved in 2 investigations where they went to jail. So my only point is, do not take this form lightly, okay? I know nobody's going to falsify, but don't take this form lightly. It gets to be routine. You do it every week, but you don't want to mess it up because these investigators love to throw that card at you. They're going to say, well, this form isn't correct, and you know that there's fines and not, well, they're not telling you that they have to prove that it was a deliberate act. But still, something to, be aware of. Now, I got to minimize that. I'm looking for the minimize. Oh, thank you. Appreciate it. So we're back to the PowerPoint now. So South Dakota DOT Certified Payroll Form, great stuff whether you use it or not. I suggest those of you that work in this, that do these forms, at least take a peek at that instructions page, okay? It's excellent stuff. Okay. We're going to talk a little bit about the site of work. And you may wonder why, but this is also another area of the law that is often misunderstood. There are often violations of this portion of the law that result in back pay and other things, so you want to be careful of it. Now, as it says up there, it's easy to know that the site of work is clearly the spot where the construction is being put together. So where the building is, or the highway is, or whatever it is that's being built, the wastewater treatment plant, we all know that's easy. That's the site of work. But as the second bullet point says, there can be other sites away from the site of work that in the eyes of Davis-Bacon are part of that site, and the wages paid for people working on this other site have to be prevailing wage that the contract calls for. Often overlooked, often overlooked. So as the slide says, if this site has been specifically set up for the project, the most common thing we see is like a batch plant for ready mix. Okay, it's a highway job or a big parking lot at a college or state school, whatever, federal money involved. So they set up a portable batch plant literally right on the site or half a block away or whatever. That batch plant goes away when the project's over. There's trucks driving back and forth, in this case ready-mix trucks, to pick up the concrete and bring it over. That is site of work, which makes those drivers driving from the actual construction site to this batch plant on the Davis-Bacon clock the whole time. Okay? So you just want to be aware that. This is very complex. And if you get into this situation and you're not sure, I strongly suggest that you get some advice, get some guidance. And let me put in a plug for ABC here. Dickinson has worked with ABC. We've been partners for a long time. And I know for a fact that there's some people there, Greg especially, that really knows his stuff on Davis-Bacon. So do yourself a favor and get the advice, before you start the job or before, people get out there and start working if you're not sure. And there's more thorny issues as well. The other thing I want to point out about site of work, and then we'll move on, certain types of contractors do a lot of work at their own shop, okay? And I'm thinking, for example, of sheet metal. And during my career as investigator, I saw a lot of sheet metal outfits that would fabricate these runs of ductwork and stuff at their shop where they had all the brakes and the forming machines and all that, and then ship the stuff to the job site where it got installed. Well, in that case, as you kind of can see from the slide here, if it's my shop that is ongoing, I've had it for 20 years, when this project's over, I hope to have it for another 20 years, and I'm just doing that, that is not site of work. So people working on part of that project that back at the home office, back at the shop, they are not necessarily, they do not have to get the Davis-Bacon wage rates, okay? The key is this is our home office and it's got other purposes other than just to serve this project. That's the key. So you do want to be aware of that too. If by some reason, chance you employ truck drivers, it's more relevant, okay? So site of work is actually an important thing. Next subject, apprentices. And again, I have to throw some kudos ABC's way because they have a fine apprenticeship program. I've worked strongly with that when I was still with DOL, and it's a great program. But apprentices are traditionally a spot where some employers go wrong, and when it comes to Davis-Bacon. And the first thing you have to remember is anybody that's listed on that form we just went through, the certified payroll form, as an apprentice and that is paid a lesser wage because they're an apprentice has to be registered with DOL, with their Office of Apprenticeship. Maybe they're on the list, maybe they haven't gotten there yet, maybe they're trainees, they can't really do the work, but if they're not registered with DOL, they have to get the full rate of pay. Okay, so remember that. Now the upside is you could have people in their probationary stage of their apprenticeship, and it's all good, they're just going through their apprentice, they get to count as apprentices. And what happens is if the DOL comes in and sees that these people weren't registered or we get into the ratios and stuff, there's back pay there. And they'll say you got to fill out the back pay to bring them up to the full journey level. So that's issue number one. Be absolutely sure they're registered before you pay them the lesser amount. But the other side of the coin is this, and you notice that I have some bolded language up there. Even if they're an apprentice, and let's say they're an apprentice, it's at the half of the rate, the 50% rate. And of course, this is all spelled out in the apprentice agreement. But in the first year, you get 50%, let's say, that it says. In Davis-Bacon, there's a wage and there's a fringe. So it might be a $20 an hour wage and $5 an hour fringe, okay? But if I can pay my apprentice half the wage, many employers think, well, I'll just pay him half the fringe too. No, you may not. Your agreement with OA has to specify that you can pay less for the fringe. And by the way, and I've checked, ABC's plan is silent on this matter, just as that says if the program is silent. So anyone who participates in the ABC apprenticeship program, any employer, any contractor, has to pay the full boat on the fringes. They get the same amount in fringe pay or benefits as a journey level full-blown person gets, even though they may only get half of the wage. And again, that's very critical, very critical. And then the second point here that somehow creates problems sometimes with apprentices is making absolutely sure you have the correct ratio. And almost every trade, almost every craft nowadays is 1-to-1, one journeyman, one apprentice. And so even though sometimes, you know, it's some foreman out on the site who put two apprentices with this journeyman for that day or whatever, you really can't, you know, do that. Again, if that comes to light, that's a double whammy. Because number one, if this apprentice, if there were 2 apprentices or 3 instead of 1, the Office of Apprenticeship is going to say those hours don't count towards their apprentice requirements, number one. And number 2, then the other side of the Department of Labor Wage and Hour is going to say, oh, and by the way, those 2 that were out of ratio, you owe the full boat on. So you don't want to make that mistake. So you want to make sure your foreman and your supervisors on the job site are aware of this too, okay? But it's a common error. It's a common error. And I don't attribute anything other than not being aware of it, okay? So by all means, keep that in mind. All right, moving forward. We're coming back again now to this idea of tracking people's time of exactly what they do. The problem is, in determining the proper classification, is this laborer work? Is this carpenter work? Is it, you know, iron worker? How do you decide? Because it's not clear. This is one of the really tough nuts, if you will, of Davis-Bacon. How do you determine what the right rate or what the right trade is for that particular employee? So classifying the worker, and then once you're classifying them, noting that, and as mentioned earlier, recording it. The hours as an operator, the hours as a carpenter. But you got to know what's what. And the problem that makes it so complex is, first off, every county is different. Okay? What happens in Polk County, where I'm sitting right now, and what is considered, let's say, carpenter work in Polk County, is 100% different than what might be down in Union County down south, or Buena Vista County up in the northwest, or whatever. It varies from county to county. Then it also varies based on the type of wage determination that your project has, all right? Now, I think we know that the big metro counties in Iowa are the ones where the unions are prevalent. So, you know, there's going to be a union wage decision in Polk County. There's going to be a union wage decision in Scott County out east, you know. Woodbury, so-so, you know, Potawatomi, some of those. But you just pick out your big cities, and those are the union ones. So what's the poor contractor to do? I mean, they're really stuck in the middle, because what works in Polk County might not work up north or vice versa. So you got to be aware of these things. But there's 3 different types of wage determinations. And for those of you that aren't, you know, familiar with the term, when you get a contract or a subcontract, you should get a copy of that wage determination issued by the Department of Labor that says, this is what carpenters get, this is what laborers get, and so forth. But some are union and some are not. So the question becomes, you know, how do we determine what's a union and a non-union or mixed or whatever? So I've got one here. I'm going to pull up, there we go, to show you. Now, this is a current wage decision in Iowa, and I'm going to get into this just a little bit. This is another one where we could spend a good hour on or more. Currently going, as you can see, it's heavy river work in Iowa. So that's our decision. I picked this for a reason, because if you remember the slide, union, non-union, mixed, this is mixed. So we have both in a single one, depending on the trade and depending on the county. But I want to show you how you can tell if it's union or non-union. And I'll explain to you why you want to know that. Why would you want to know that? If you're working under a union wage determination, even though you're not a union contractor, you could be working under a union wage determination for Davis-Bacon. You got to follow those rules. And it's not the most pleasant thing, but you got to do it. And back to my idea, and I'll just quote you a real case that happened right before I retired. And the question became pulling low voltage wire through a conduit. Okay. Now, it wasn't regular wire, it was low voltage. It was, well, there were 2 cases, actually. One was traffic lights, and the other was a big building down at a community college campus down south where they're pulling all this low voltage wire. And they're paying all these folks as laborers. Well, you know, what is the area of practice? What did the, you know, if it was union, we would have called the union. This is what Department of Labor will do. They'll just call up the union and say, how do you guys handle this? Well, we electricians claim it. Well, then you got to pay the electrician's rate. You may never have paid the electrician's rate in other jobs, but because you're on this job in this county under this wage determination, you got to pay union. And we're going to deal with this a little bit more. So it's absolutely critical that you know when you're looking at this wage decision. Well, fortunately, for once, the federal government has kept it fairly simple. Because look at this wage determination. This is the header. This is page 1. And I highlighted the section I wanted to show you for now. When you see the county and the job, so these are Carpenters in Scott County, you're going to see a little title right up here. And when it starts with 4 letters like C-A-R-P that match the first 4 letters of the trade, Carpenters, well, that's Carpenters Local, I'm guessing Carpenters Local 4, I'm not familiar with it, in Scott County. So that's a union rate, and that's the union that's going to control what's carpenter work, okay? So you want to know that because it's going to help you decide how to pay your people. So the rest of these are very similar. I'm not going to beat it to death. So here's engineers in these other counties. So that's engineers local 150. You know, that's easy to see. I'm going to go down because I got more to show you. Oh, and by the way, if you're fortunate on these wage determinations, there will be this descriptive language down here. So it'll tell you when there's multiple groups at different pay rates, what is what. So if I'm an asphalt paver, I know working on that, I know I'm a group 2. This is very helpful. Not all wage decisions have these. So keep your fingers crossed that you're working with one that has this description. There's another different engineer local because of the fact that it's different counties. But I want to find you a non-union. Okay, there's iron workers, there's laborers. Now, once you see there's the cement masons who work under the plasters, the teamsters, etc. Now, once you see this right here, SUIA, that is short for Survey Iowa. Now, these rates are non-union rates. So the union on these types of jobs in these areas don't get to control who does what. It's a non-union rate, so we go back to this area practice thing, and we're going to talk about that in a second. So that helps you to know that you don't have to pay just like the union, you know, when you're doing this work, if it's a non-union rate. And of course, I think it goes without saying that generally, not always, but generally the non-union rates are a little bit lower than the union rate. So, but it's really important for you as contractors to know when you see this decision, whether you're working under a union decision or a non-union decision, okay, in your county where you're doing the work. So let's go back to the PowerPoint for a sec. There we go. So that was a mixed one, and that's a perfect example of what a wage decision looks like. Now, I'm not going to get into this very much, but I just want to show you this slide, and you can look at it later. If the Department of Labor is trying to determine what the area practice is, in other words, in that area what a carpenter's claim or electricians or whatever, this is what they do. They actually will contact companies, contractors who do that type of work in the area that the project is being worked on. And they will ask each one of them. Now, we've got people pulling low voltage wire through conduits. How do you pay that when you're doing a job in this county? Well, we pay them as laborers. Okay, and they just literally count them up. And if 10 contractors tell them they pay them as laborers and 2 tell them they pay them as electricians, it's going to be labor rate, or vice versa. Now, you know, it's not a very exact science. You can see that. So again, you want to be very careful that when you're in these places and your people are doing their work, that they're classified correctly. And again, if you need help, this is an area where seeking some advice is really, really important, okay? And again, you can see why to make this decision as to how to classify is a little easier in the union counties, even though you have other hassles, of course, you got to put up with. So be aware that that's an important thing. It's one of the most important things that those investigators are going to be looking at, how you classified your people, all right? Okay, how are we doing on time? We're doing great. Now, we're going to talk about fringe benefits for a minute. And fringes are another area where it's easy to get messed up, and without even trying. And believe me, you know, there's hundreds of stories I could tell you. By the law, by the Davis-Bacon law, these fringes got to be paid for every hour that employee works on the project that week, okay? So you just got to make sure you pay it. Now, if by some chance you send a crew to do a Davis-Bacon job in some rural county where the cash wage that you normally pay these workers is higher than the Davis-Bacon rate, let's say up in Buena Vista County, Storm Lake, Iowa, you can take credit for the amount of your wage that's over the wage determination wage towards the fringes, so that's a good thing. The thing you want to remember in Davis-Bacon, if my wage says 20 and my fringe says 10, that's $30. So I just have to ensure that my employees get $30 an hour for that work, and it can be divided up between wage and fringe any way you want, but it's got to total 30. So if I normally pay my guys $25 an hour, and I'm going up here where I only have to pay them 20, well, I got $5 to apply towards that $10 fringe then. So that's a good thing. The other thing that you want to always remember is the fringe portion is not part of the overtime calculation if this employee works overtime that week. Okay? So like my $20 and $10 example, if the base rate is $20 an hour, the overtime is time and a half to 20. Okay? It's not time and a half, the 20 plus 10. The fringe has got to be paid for those overtime hours, but you don't pay the extra overtime, pay the extra half. So keep that in mind. And that's a break, of course, too. The fringes are just straight time only, not time and a half. So do keep that in mind. All right? Now, the simplest way, the easiest way and the best way not to get, messed up is to just go ahead and pay the fringe in cash, and of course we mean on the paycheck. So my 20 and 10 person gets a paycheck for $30 an hour. If they worked overtime, they get the proper overtime. We're all good. We've met the wage, we've met the fringe, and we're all good. That's good. Now, the deal is in real life that doesn't happen because maybe the contractor's already picking up some health insurance or some other benefit that they can take credit for. So that's where they talk about contributing payments to a bona fide plan. Or, what is probably the most common thing, at least from my experience, is a combination of the two. I'm paying health insurance benefits for my, or premiums for my employees. It comes out to about worth $1 an hour, but the fringes are $3 an hour. So I give them the insurance, that's worth $1, and I kick in the extra $2 on their paycheck. Perfectly acceptable, any combination of the two. And again, I want to draw your attention to one particular term here, and that's bona fide. And what that really means is that the Department of Labor says they're okay, in the real world. And so what does the Department of Labor consider bona fide fringes? These are the basics, okay? So an employer that's picking up premiums for these insurance type policies or contributing to a pension plan or 401k or 2 weeks paid vacation or paid holidays, whatever number of paid holidays, sick leave, all that stuff. Those are all forms of fringe benefits that the employer can take credit for against the Davis-Bacon fringe, all right? But again, there are rules there. Now, what you want to be careful of is this. The Department of Labor doesn't just accept any old thing that the employer says they want to take credit for. And some don't make any sense. These cafeteria plans that are out there where, there's a pot and the employee can pay child care costs and all kinds of things out of that cafeteria plan. That's really at issue. It's been at issue for years. But daycare, for example, a reimbursement is not a bona fide fringe under Davis-Bacon. So again, if you're going to vary from any of these standard fringe benefits that you're offering and want to take credit for them, you need to get some advice. And whether that's, starting with ABC is what I'd do if I were you, or whomever. But Greg calls Russ or I when he doesn't know the answer. So I think between the three of us, we've got them figured out pretty well. The thing I want to caution you most of all, and this is a very common thing, again, mistake. The contractor's got a job 200 miles away, and they're paying per diem. You guys are going to be out in Davenport for the whole week. We're working out there. So I'm giving you $25 a day for food, and I'm paying for your hotel. Then the employer turns around and claims that as a fringe benefit and totals up their costs and says, I get credit against that $5 an hour fringe. No, that's not going to fly. The department has already ruled, the Department of Labor, that those type of expenses are really for the benefit of the employer just as much, if not more, than the employee. Now, is that true or not? I don't know, but that's what they say, and you got to go with what the law says. So, as much as you want to do that, you can't take credit for those fringes. Now, if you say to yourself, well, fine, I just won't pay them, for their living expenses on the road, but you're paying them the exact wage that the contract calls for, you got a problem there too, because that cost to the employee of their hotel, motel, whatever, campsite, and their food is, well, not the food because they'd have that at home, but that lodging cost, if it in effect drops them below the prevailing wage on the determination, then you got that problem too. So if you're sending them out of town where they have to stay overnight, you're pretty much on the hook to pay for it, but you don't get to take credit for it. So do keep this in mind. Now, this is only the beginning of the issue with fringes, though, and this is why fringe benefits get to be such a bugaboo for contractors. Sorry, I hit too many. There's not only, those fringes I just mentioned, these bona fide fringes, but there's different kinds of plans out there. And these are all spelled out by the Department of Labor. This type of plan is something where you've got a third party helping you with it. It'd be your 401k where you're contributing to some financial institution that manages it, or a straight up pension plan. Some of you have heard or even maybe used these supplemental unemployment benefit plans that are offered by various financial advisors and groups. So when you've got a third party and the employer pays in and they don't have the right to take it out. I mean, once it's paid in, it's paid in. And the contractor has to contribute to this plan at least once a quarter, then everything that contractor puts in that plan is creditable towards the fringes, okay, everything. So that's if you go all that 9 yards on a funded plan. Now there's another plan which is much more common, an unfunded plan, and I call this an in-house plan. This would be something that my company just decides to do. We're going to give everybody 2 weeks paid vacation a year. So I know what Jared makes and how much it's going to cost me for 2 weeks of vacation. I figure out my cost and I take that as credit towards the fringes. I'm good. That's totally reasonable. So that's what they call an unfunded plan, mainly because there's no third-party oversight or third-party administrator of the plan. But it has to be a commitment the employer makes that can be enforceable. I'm going to contribute X amount, 1% of your pay, to this 401k, or 1%, yeah. Or it's got to be a financially responsible plan. What does that mean? Quite simply, the numbers have to add up. Because as an old investigator, I can't tell you how many times I went into a contractor and they said, I'm taking $4.50 credit. When I totaled up the cost, it was about $1.50. So the numbers better match up. That's what they mean by financially responsible. And of course, you have to give the employees heads up, a notice ahead of time. Here's what we're doing. We have a 401k, we have a pension, we have this, and you get a benefit from it. So those are the 2 types of plans, generally speaking. Now, we're not quite done because you got one other thing that is, again, creates major problems. I'm just going to skip to the very last bullet point and take a look at that. Allocating fringe benefits. Davis-Bacon work may not be used to fund benefits for private non-Davis-Bacon work. Well, unless you're one of the very few companies, if any, that live in Iowa, there are a few, that all of their work is Davis-Bacon work, your folks are going to have some work on federal projects during the year and some works not on federal projects. So what the Department of Labor said is you need to average the cost of these benefits out over all of the hours worked, not just Davis-Bacon, all right? So let me give you an example, and I'm keeping it simple, but the employee, you figured out that you paid $3,000, towards this employee's health insurance for the year, and that employee worked 2,000 hours, okay? Well, you divide 3,000 by 2,000, it's $1.50 an hour, right? For all hours. So that employer then could take $1.50 credit towards a Davis-Bacon fringe for that paying those health insurance premiums. Makes perfect sense. But let's say that year my employees only worked 800 hours on a Davis-Bacon job, on Davis-Bacon jobs. If I made the mistake and took that $3,000 of insurance premium divided by 800, now I'm up to almost $4 an hour credit. And a lot of employers mistakenly will do that, and then they show $4 of credit towards fringes. No, that's not right. It was only $1.50. And if the Department of Labor comes in, they're going to say you owe the difference back to the employee. So you don't want to be in that position. So when you annualize, it means you're just spreading that out over the whole year or the equivalent of the year. You can do your math on the month or whatever. But it's absolutely essential you use this for things like vacation pay, health insurance, things like that. Okay? Very good. Now, I want to go into this too because this is going along the lines of what we've talked about now for the last half hour or more. Many, many work weeks, you're going to have an employee that's wound up getting paid 2 different rates in that same week. Now, it may be on our screen here, like this person who was an electrician for 20 hours in the week and a painter for 24. Maybe they were on the same project. They just spent 24 hours painting and 20 hours as an electrician. Maybe they went to a different project. Or maybe that painting hours weren't Davis-Bacon at all. The bottom line is you're obligated both under your federal contract and the general overtime law of the U.S., the Fair Labor Standards Act, to pay people time and a half, appropriately for their pay, which is easy when they get 1 rate of pay. This is how you do it if this employee got paid 2 rates of pay. So I'm not going to read all the math off. You can see that. But what you do is you take all the straight time pay. You see, we took their $32 hours and we took their $23 hours, totaled them up, and we came up with that $11.92. Then you divide that by the hours that employee worked in that period. So this guy worked 44 hours. So in effect, even though he was paid these 2 rates, it worked out to $27.09 an hour. You follow me? Then to figure the overtime, you take that $27.09 times 1/2 times the overtime hours. Now you're saying, why, Mike, why are we doing 1/2? Well, the $27.09 is the straight time for all 44 hours. So we already got our straight time taken care of. All we need is the extra half to bring them up to time and a half for those 4 hours. So this is the math on how you do it. Okay? And again, you want to make sure you're doing that right because they do check for this, particularly the Department of Labor investigators. The HUD people maybe not so much, or the DOT people, but the DOL people really will. Now, there's another legal way to pay overtime I'll mention to you, and I'll mention to you its pluses and minuses. If you choose, as the employer, you could track this person's hours, and when they hit hour number 40, you could determine were they working as an electrician from 40 to 44, or were they working as a painter from 40 to 44, or some of both. But that even gets more complicated. But let's assume for our discussion that they were working as a painter. If you pay the overtime at the rate that of the job they're working in, or in the overtime, that's legal too. So I could pay this person time and a half, $23 an hour if all the overtime was spent as a painter, or vice versa if all the time was spent as an electrician. The downside is it's a pain in the neck to track. You got one more piece of paper, or one more line item on your paper that's already got to show the hours and what jobs the person did, and now you got to show what they did from 40 to 44. And the first thing the Department of Labor is going to look at when they come in, if you pay that way, is they're going to go through this overtime and make sure that there were some weeks that they got the higher rate of pay in the overtime. Because if every single week they were paid time and a half on the lower rate, that's a major red flag for the investigator, and they're going to explore that and dig into that, okay? So be aware of that. This is just simpler with Excel. You can create an Excel spreadsheet. You don't have to be tracking these hours. If I were in business, this is what I do, but you still have the other option. So be aware of that, okay? Now we're going to get off track here a little bit because this has to do with Davis-Bacon. We're kind of winding down anyway, so we have time for some questions. But there's a couple executive orders that those of you that have had contracts or will have contracts you need to definitely be aware of. And let me just diverge a bit and say no one's attacked these executive orders yet. Many, many labor orders, have fallen by the wayside with the new administration, and that's what they do. But this one here, this minimum wage thing, goes back to 2015, and it's so far back that the administration is limited on what they can do. They could write a new executive order that wipes this one out, but we haven't heard anything. So right now, this is the law of the land. And I want to again focus on these bolded words. So allow me to summarize this. Workers performing on or in connection with federal contracts whose wages are governed by fair labor or Davis-Bacon are entitled to receive the executive order minimum wage for all time spent performing on or in connection with the federal contracts. Now, the rate is $10.20 an hour right now. Now, for your people who are working on the job site and are subject to prevailing wages in the wage determination, it's very rare these days that there's anything on those wage determinations less than $10.20. But I think there are a few out there. And I'll show you on the wage decision after this slide, or the next slide, that it gives you a heads up right on the wage determination. But that's not the big deal here. The big deal are these people in connection with. So who is that? These are people who may never show up on the job site. This could be your payroll person who's doing payroll for federal jobs, who's filling out the certified payrolls. If you had to hire, say, some security to keep an eye on this job site, you know, after hours when you're not around or anything like that? No, they're not performing the construction, but they're in connection with. You have to ensure, if they're your employees, that they're all getting 10, 20 an hour. Not for all hours, but for the hours they're doing their work. Like your payroll person, if he or she is spending 6 hours a week on payroll, well, then that'd be 6 hours on federal payroll. That'd be 6 hours at that rate, unless they're already getting it. And again, I suspect most people are above 1020, but you do want to be aware of this, because there's a second executive order that came a little bit later, but essentially says the same thing, only for sick leave. So employees subject to the Davis-Bacon Act, including in connection with, are entitled to up to 7 days of paid sick leave as required by this law, or this order. It's not a law, it's an order. And what that means is every hour that they work on the contract, whether they're a carpenter working on site or the payroll person back at the office, they get 1 hour of accrued sick leave for every 30 hours worked on the contract. Okay? And again, that is a requirement. They will be checking that. It's relatively new, but the Department of Labor, especially if they come by, they will be checking it. And again, this slide makes it very, very clear that it's people working in connection with. Now, the break here is that somebody who spends less than 20% of their hours, now this doesn't count on the job site people, this doesn't count your carpenters and electricians and laborers, this is your payroll people and your security guards. If they spend less than 20 hours a week on contract work, then they don't have to get the sick leave. They still have to get that minimum wage, but they don't have to get the sick leave. So if your payroll person works 40 hours a week and spends 5 hours a week on payroll for federal, she wouldn't have to get to 1020 if she's not already getting it, because less than 20% of her time was spent. So in all the other stuff that goes with Davis-Bacon, don't forget the minimum wage and don't forget the sick leave. All right? Now, we're getting down towards the end, and I want to see if we got any questions. Let's click on questions. I'm not sure there are any questions. Oh, here we go. Can we open that up just a tad? Can you help me out with that? Provides material. Oh, there we go. Let's just go up all the way to the top. I'm going to read that one, and I'm going to read them out because I don't think you can hear it. Oh, okay. We're seeing the ones that said we can't hear, and now we can hear. Okay, here we go. Does the minimum wage rate apply to suppliers and vendors that provide material to the job site? Well, the minimum wage rate, the one we just talked about, no, it does not, that 1020. But the prevailing wage, there we go, the prevailing wage may apply. And here's what they say. To a supplier, if I'm a well, just say I'm a ready-mix supplier, and my ready-mix driver spends more than 20%, I'm a ready-mix employer, of their time on a Davis-Bacon job site, they're going to have to get Davis-Bacon wages for truck drivers for that wage. Now, if I'm the contractor and I'm doing the contract work and I also happen to have a truck driver, that doesn't apply. But you talked about material suppliers. It's called the 20% rule. The employee of the material supplier has to spend 20% of their work week on one or more federal jobs before the Davis-Bacon Act applies. Okay, and again, the drive time typically would not be. It could be, but it's their time spent on the site typically. Okay, let's see. We have another one. Oh, for example, a duct supplier that provides material to a mechanical contractor. Exactly. If that duct supplier's employees are spending more than 20% of their time on that Davis-Bacon job site, they got to get the rate, the prevailing rate. Okay? I think that does it. The sick leave applies to every employee, even though they normally don't get paid time off. The answer is yes. This is a presidential order that says if you accept this federal contract, even if you don't typically pay PTO, you've got to give that person the 1 hour accrued sick leave for every 30 hours worked, on or in connection with the project. Okay, so it wasn't done as a question, but okay. Next question. When calculating Fringe, you take the total employer contribution annually and divide that by 2080 working hours per year, or the actual working hours per year. But yeah, for our example, vacation would be deducted. You're absolutely right. It's hours worked, it's not paid time off. So if the employee worked 2,000 hours and had 80 hours of vacation, for the purposes of the Fringe, you'd use 2,000 and divide by 2,000. So that's a benefit because you get that much more credit then for the Fringe. Okay. Next question. If an employee works in multiple positions, such as a laborer, an operator group 1 and operator group 3, then as long as we pay them for the highest position for that day, we're okay, right? You're absolutely right. If you're paying them the higher of the two, you're never going to have to worry. Where the Department of Labor is going to be on your case, frankly, is if you're paying them the lowest of those 3 rates for all the hours they work, okay? So these are great questions, you guys, just excellent questions. So we got a minute or two if there are any more. We've got 5 minutes to go. Any other questions? We'll give you a second. Anything else, Jared, you want to point out?
No. Thank you so much, everyone, for your time, and thank you, Mike Staebell, for giving this his time today to discuss this very important issue within the construction industry. So
you're welcome. Thank you.
Let me say, looks like we have one more question here.
Yeah, we'll take questions as long as you want to go, because and I have a couple things to add too, but thank you so much, Jared. How do you determine the number of hours an employee will work that year? Do you use the previous year to determine that number? The answer is yes, you use the prior year. Now, where it gets really dicey is a brand new employee, okay? And even the Department of Labor isn't super clear on that. I had laughed my whole career there that they never got that together. So there's various ways to go. Here's, in these areas, what's so important is that you give it your best shot. As long as you're making a good attempt, you know, a good faith attempt is the legal term to follow the rule. So you might have this person working in a crew or whatever, and you know what that crew worked last year, and this employee, you know. But if the employee didn't start till halfway through the year, of course, you got to adjust that accordingly. Or you can take, on a brand new employee, you could go monthly if you wanted to go monthly. You could do that. But for those new folks, for everybody else, it's your people who come back year after year, you use the previous year to make that determination, okay? But I just wanted to say, again, I want to say thanks to ABC because you guys are great. You really are. And you do so much. And you're very fortunate, you folks on the web, to be members and have them and really use them, you know, as much as you can because they're here to help you. They really are. They really are. And as I blab on, we get one more question. So if the prior year an employee worked 3,000 hours, obviously includes overtime, you'd use all 3,000 hours. Correct. You've got to use those hours. Now, again, it's an inexact science. So last year you used 3,000 hours. This year we have the wettest spring in history. And we're a month late getting started on our outdoor construction work. You know, you can take that into consideration, you know, if you choose to, and say, well, we had 3,000 last year, but look, we only had 3 rain weeks all last year. You know, here we are in the 1st of May, and we've already had 4 rain weeks. You know, I mean, you can, but you have to be able to justify that. Remember what I said, the numbers have to add up. And if that investigator comes to visit you and says, tell me how you computed this Fringe that you're claiming for $2.25 an hour, as long as you're reasonable and you can make it work out, and it's not just something you know, came up with. I mean, it's based on reality, you're going to be okay. It's the people that, as I say, only use the Davis-Bacon hours, or we had a training one time, and this company was claiming it's like a $10 an hour credit towards training, and they didn't even have an apprenticeship program. Well, and it was, I'll be honest with you, it was a union shop, so you can all clap in the background, but, and it turned out they had some kind of a scam thing going with the union. And I can say it out loud. I mean, I can say the employer, but it was in the paper and everything, and it was just like almost a skimming thing. I mean, we determined they were probably spending about 75 cents an hour on actual training, and they were claiming $9 an hour. Some of these employees got back paychecks for $30,000 over 2 years. The last thing I'm going to close up with. Oh, yeah, we got another one. 2 more there. Okay. If the Fringe benefits exceed, then may we use that amount towards the wage? The answer to that is yes. For example, they made $19 an hour, and their Fringes are $11, and the Davis-Bacon wage is 20 and the Fringe is 10. In other words, you go back to that, you don't have to make a wage adjustment. No, it's the total package. If $30 is the combination of the Fringe and the wage, and you're paying 30, even if your combination isn't the same as on that decision, you're okay. It's the total cost that really counts. So that question would be absolutely okay. Do we have another one? Oh, yeah. Oh, hey, that's a good question. When you add the accrued paid sick time, can you take credit for that as part of the Fringe? Boy, you guys are thinking. I like this. I did not know the answer to this until yesterday, and I actually checked it out. I did a whole bunch of checking, and I found out the answer, and the answer is best anyone can say, because it hasn't really come up on the Department of Labor website or my sources or anything, is that yes, you can, because the employee's getting the benefit. They get paid for those hours they're not working, if they're sick and they use it. So yes, if they get the full 8 days, or what, there's 7 days. I'm 7 times 8. Yeah, if they get the full 7 days, you could take that amount. But again, you got to divide it by all hours, not just the Davis-Bacon. So the answer is yes, you may take credit for that.